Now, the sentencing agreement that I've been provided with today, it appears to have your signature on it, and it says Nancy Smith. Did you sign this agreement?
Yes, Your Honor.
And before you signed this agreement, did you go over this agreement?
Yes, I did.
Did you read it yourself?
Yes, I did, Your Honor.
And did your lawyer also go over it with you?
Yes, she did, Your Honor.
And did she answer any questions you might have had? Did she explain it to you? Did she do anything that you needed her to do so that you fully understood?
Yes, she did, Your Honor.
And were you satisfied at the completion of that you fully understood this agreement?
Yes, I am, Your Honor.
The court has reviewed the sentencing agreement. And the court's made inquiry of all counsel and of the defendant. The court is satisfied that counsel and the defendant have made this agreement. The court is in particular satisfied that the defendant has knowingly, voluntarily, intelligently, and competently entered into the sentencing agreement. The court finds that the sentencing agreement shall be adopted by the court, and I'll get to the basis of that in a minute. The court, first of all, orders that the language of the original sentencing entry shall be revised to comply with the Supreme Court of Ohio's mandate, in that it will indicate that the defendant was found guilty by trial by a jury, because that was the indication from the Supreme Court. The prosecutor shall prepare an appropriate entry to that effect. And the exact language of the rule which the court adopts is that the defendant was found guilty by a guilty verdict from a jury trial. She will be sentenced to a term of 2 years on count 1 of gross sexual imposition. That's pursuant to 2907-05-84. She'll be sentenced also to 2 years on count 2 as amended to gross sexual imposition for a period of 2 years, also 2907-05.84. To a term of 2 years on count 3, which is amended to gross sexual imposition, 2907.05.84. To a term of 2 years on count 4, amended to gross sexual imposition, 2907.05.84. To a term of 2 years on count 5, amended to gross sexual imposition, again pursuant to section 2907.05.84 of the revised code. And then in case number 94 CR 045368, should be sentenced also to a term of 2 years on the 1 count of gross sexual imposition, 2907.04.84. All these sentences, by the stipulation of the parties and by the court's authority, shall run consecutively for an aggregate term of 12 years. The defendant will be given credit for time served up through today, which means that the sentence has been completed in its entirety. There is no registration requirement under Ohio law, and the court